Hello, everybody. It's great to be with you. Happy October. Hoping that you are enjoying these first days of fall as we move into that season where there are pumpkins and leaves falling and all the rest, wherever you might be tuning in. It's always active, however, and no matter what season it is, and we have plenty to cover on today's program. And so if Kathy, if you could please move to the next slide, I'll walk through the agenda and just give everyone a sense as to what's coming here. So first, after I'm done with these opening remarks, Michael Donlan's going to be back with us. Michael, you may recall, is a member in our Buffalo office, and he has presented before on issues relating to the SEC, and he's back to give us some updates, including specifically concerning whistleblower enforcement actions. We're really glad that Michael can make this time. Elizabeth Morgan, who also has been with us. Liz is out of our Syracuse office, and Liz has been on the employee retention tax credit beat, as it were, making sure that all of you get the information you need. And Liz is going to tell us more about where that program stands. There's been a ton of scrutiny. All of you are familiar with the fact that it arose out of the pandemic and served as a lifeline to many businesses, but there are lots of questions about, ultimately who did and did not deserve to have access to those funds. That's all ongoing and still shaking out. And then we will move to our next speaker, who's new to our program, and that's Chris Cruz Sierra. Chris sits here in the New York City office, just down the hall from me. Chris is an associate who focuses on school law matters, and we're just delighted that he can make this time. And Title IX is the topic generally that he'll be talking about, and we'll get into the details momentarily. But for now, I just want to thank all of you for, again, taking the time to tune in, for being the loyal viewers that you are. We continue to want to make this webinar the best that we can for all of you. So as I've said before, and I reiterate, reach out to me and let me know, what it is that we can do better, what it is that we can improve upon, because we always want to hear from you about it. So with that noted, let me turn to that first speaker I mentioned, and that's Mike. Mike is out of our Buffalo office, and we are grateful as always that Mike can make the time to be on this program. He has a practice that really focuses on corporate and securities aspects, of complex business transactions, and that is why he's well positioned to give us updates on what's happening at the SEC. And so with that, Mike, really glad you can make this time, and the floor is yours. Please go right ahead.
Great. Thank you, Gabe. And good afternoon, everyone. So this edition of the SEC Regulatory Update is going to focus on recent whistleblower enforcement actions, specifically the SEC's focus on what they believe to be problematic provisions in employment and separation agreements that they view could impede whistleblowers from reporting potential misconduct to the SEC. Kathy, if you could go to our first slide. So as a background, Congress established the SEC's whistleblower program to incentivize reporting of specific, timely, and credible information about potential violations of the federal securities laws. Under the SEC's whistleblower program, I note that eligible individuals who present what they deem to be high quality original information that leads to an SEC enforcement action may be awarded up to 10 to 30% of the monetary sanctions that the government collects. As recently noted by the SEC's Office of the Whistleblower and the chief of that office, she said that ensuring that potential whistleblowers can communicate directly with the commission is a critical part of the SEC's oversight mandate. As part of this enforcement mechanism, the SEC adopted Rule 21F-17 of the Securities Exchange Act of 1934, and that prohibits a company from interfering with a person's right to report possible securities law violations to the SEC. The rule states simply, no person may take action to impede an individual from communicating directly with the SEC staff about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communications. Next slide, Kathy. So this rule became effective in August of 2011, and the SEC really started with their first enforcement actions in 2015. And the SEC all along has made clear that the enforcement of this rule is one of its priorities. The SEC has repeatedly used this to bring cases against companies that have included provisions in their standard separation agreements or employment agreements that could be read to disincentivize departing employees from raising concerns with the SEC. There were 4 cases that were brought in 2023. And I note that the SEC brought these cases even where there was no evidence that the company actually enforced the provision to chill any particular whistleblower, or that these provisions actually discouraged a whistleblower from coming forward. In 2023, I also note that one of those cases against a company called Monolith Resources, an LLC in the technology and energy areas in Nebraska, that case served as a reminder that private entities are under the SEC scrutiny, not just publicly traded companies and their officers and directors. This just shows you that the SEC believes that its investigatory authority extends to basically anything and anyone and anywhere. Next slide. So last month, I note that today is the first day of the fiscal year of our federal government and of the SEC as well. I'm wondering whether they always bring these actions in the waning months of a fiscal year to pad their coffers a little bit. But on September 9th, the SEC did announce 7 settled enforcement actions under Rule 21F17. These settlements imposed civil penalties ranging from $19,500 to $1.39 million. So about $3 million in the aggregate for the 7 companies here. I note that the penalty amounts appear to be largely driven by the number of problematic agreements that were identified by the SEC. And of course, I say identified by the SEC, recognizing that they require you to disclose any and all documents that could be responsive to their inquiry here. So you're basically giving them all the ammunition to determine what penalty they're going to impose upon you here. The low end of the range here was a unique situation where the company actually was in financial distress. It had issued what's called a going concern opinion with respect to its financial statements, and had limited funds on hand in order to pay anything. So their penalty was relatively modest. All the other ones were in the 6 or low 7 figures for the penalties here. I also note that the SEC assessed these penalties notwithstanding any remedial efforts that were undertaken once they were approached by the SEC. And also notwithstanding the fact that these provisions had never been invoked to prevent a party from making a claim or seeking compensation as a whistleblower. The SEC has just simply concluded that the potential chilling effect on whistleblowers is sufficient to form a basis for a violation of this whistleblower protection rule. Next slide, please. So we've all seen these types of agreements, and I'll say that crafting the waiver and release language in a separation agreement becomes a little bit of a game of cat and mouse when you're talking with the SEC. At first, companies, we've all seen it, use very broad waiver and release language, an employee waives release and forever discharges an employer, which is defined very broadly to include a bunch of affiliated persons and entities, from any claims, which is similarly defined very broadly, that they may have ever had, now has, or hereafter shall, or may have against the company, for, upon, or by reason of any matter, cause, or thing whatsoever, from the beginning of time through the date of this release. We've all seen that language there, very broadly worded. The SEC obviously would object about to language like that because it does run squarely in violation of Rule 21F17 because it doesn't have a carve out for being able to have a claim that gives rise to a whistleblower action through the SEC's whistleblower office. So upon the adoption of Rule 21F17, a lot of public companies revised their general releases to include a explicit override provision stating that nothing in the agreement would be interpreted as limiting the employee's ability to file a claim or a charge with a government agency. Part of the cat and mouse game here, some companies, took it a step further, and we'll see some of the problematic language that was identified by the SEC over the next few slides here. So Kathy, if we could move to the next slide, please. So here is an example of a separation agreement that, although it explicitly permits an employee to file a claim or a charge with government agencies and to also participate in government investigations, but you see the language at the end that it prohibits an employee from actually receiving any form of financial award for such participation. And the SEC found that to be problematic because they believe that the financial incentive is a necessary component to the efficient operation of their whistleblower program here. And as I said, from 10 to 30% of the monetary award here would have resulted in, low six-figure recoveries for a whistleblower in these sorts of situations. The largest whistleblower monetary award that I saw was in the $20 to $30 million range for the individual who brought forth that credible information. If we go to the next slide, we'll see another example here of problematic language that required an employee to represent to the company that they had not filed any complaints with a governmental agency. The SEC found this type of a representation to be problematic because there is the ability to make a whistleblower claim on a confidential and anonymous basis here. So a contractual representation on your way out the door as a departing employee that you have not brought any claims would run afoul of your statutory right in order to make a confidential whistleblower complaint with the SEC or other government agencies, but I'm primarily focusing on the SEC here. And if you look at the next slide here, we will see a third example, this one involving a confidentiality provision involving a contractor. And this was actually in two, similar language was used in two agreements in this batch of 7. These confidentiality provisions permitted disclosure of confidential information by the consultants to government agencies and regulators, but only to the extent that it was compelled by a court order or required by law, which obviously would then prohibit voluntary whistleblower disclosure to the SEC. So they found that to be problematic. Second, this example also requires the consultant to give prior notice to the company before they make that disclosure, which, as I said, the SEC also found problematic due to the confidential nature of these complaints at times. I note that the inclusion of consulting agreements in this SEC enforcement activity reiterates that the principle under Rule 21F17 is not limited to the employee-employer context. Go to the next slide, Kathy. We will look at some key takeaways from these actions from the SEC here. So, as I said, it becomes a little bit of a cat and mouse game with respect to the preparation of these agreements and then finding language that is not going to be found to be problematic by the SEC. So we encourage companies to regularly review and update form agreements and policies that may address whistleblower rights in light of this guidance here. We always recommend that confidentiality provisions should include an affirmative voluntary disclosure right of potential violations of the federal laws, specifically the federal securities laws, and without a requirement to notify the company beforehand. With these enforcement actions in 23 and 24, we clearly would advise that the agreements do not include a limitation on the employee's ability to seek a monetary award under the whistleblower program. With these new enforcement actions here, representations about an employee not having filed complaints should also be either removed altogether or revised to provide for a clear exception for protected whistleblower activity. And although wasn't the subject of any of these enforcement actions here, there's other possible ways that the SEC could look at this next year. So we would encourage you to look at such provisions like a non-disparagement or a cooperation provision, which could be viewed as being chilling whistleblower activity. And as I said before, it doesn't just apply to employment and severance agreements. It also applies to consulting arrangements. And I also reiterate that although primary focus of this is on actual publicly traded companies here, the SEC has enforced this rule broadly to also apply to private companies here. So in short, I encourage everybody to who works on these types of documents to review them across your entire business to make sure that they appropriately carve out whistleblower activities from their confidentiality and other restrictions, and to avoid restricting related activity in any manner here. I encourage you to reach out to me or your normal contact at Bond if you want to discuss any ways to address existing or past agreements that could be read to be viewing as chilling the effect on the individual's ability to communicate with the SEC on these matters here. And I appreciate your time this afternoon.
And Mike, we appreciate your time. Thank you so much for walking us through this material and for offering to be available and follow up. It's really useful to have these periodic updates on SEC activity as it affects many of those tuning in. And so speaking of programs that may touch a number of you, we have been fortunate to receive periodic updates on the Employee Retention Tax Credit Program. This is one that came out of the pandemic. It was intended as a lifeline for struggling businesses needing to find ways, as the name suggests, to retain employees. But it has become one that is highly scrutinized, where there are lots of ways in which the story is still being written. And so Liz has been on the program a number of times over, including to discuss this topic. For those of you who don't recall, Liz is based in our Syracuse office. She did her law school training at Syracuse and also has an MPA from Syracuse. And in the work that she does with clients, focuses on businesses, including nonprofits, on corporate issues and transactional matters. I've had the pleasure of working with Liz on a few such challenges, including an employee retention tax credit matter. So Liz is deeply enmeshed in this world, knows a thing or two about it. And Liz, we're looking forward to learning what it is that is the latest right now on this program. So please go right ahead, and thank you for coming back on.
Thank you, Gabe, for the update, and it's great to be back. Hello to you all. So today I'm going to talk about the employee retention tax credit, as Gabe prefaced, and as for those of you familiar with the program, this has been around for a while. It was implemented by the CARES Act, and it was a lifeline to many eligible employers. But if you read the news, the IRS has really increase their scrutiny on the program, as I'm going to go into today. Kathy, would you mind going to the next slide? I'm not going to go into this that much depth, because for many employers, the ship has sailed about whether or not they're eligible to claim the credit. But what I'm going to talk about really does touch upon these eligibility factors. So in general, as an overview, certain eligible employers, they were eligible for the credit if they met one or two eligibility factors. The first one that I have written up here was whether or not the employer sustained a full or partial suspension of operations due to a government order. The second one was whether the eligible employer experienced a significant decline in gross receipts. And so there were two periods where you could claim the credit: 2020 and 2021. You would amend your payroll tax returns. So the period to amend your 2020 payroll tax returns has since closed, but you can still amend your 2021 payroll tax returns. There was a moratorium. The IRS was not accepting any more amendments to their payroll taxes because of the abuse in the system, but they've opened it again, and they're starting to reprocess these claims and increase scrutiny. So what I'm going to talk about is not necessarily the second eligibility factor that I mentioned, the reduction in revenue, because that's really kind of black and white. Really, if your balance sheet says that you have a significant decline in gross receipts, which meant in 2020, if you were 50% down, in 2021, it meant if you were 80% down, that was pretty cut and dry. So if your analysis is based on that and you have supporting documentation, great, not too concerned. It's the first one. And what I've talked about in this program before is, I'm sure you may have seen commercials or billboards of these consultants or promoters that the IRS said, they call them promoters, these companies that really popped out of the woodwork, seeing an opportunity, seeing a lot of cash, particularly to be made by employers that may or may not be eligible for the credit. And they would say, hey, you may be eligible for a lot of money, very little downside. Sign this contract, we'll just get a slice and we'll disclaim all liability, or they will fully indemnify. That's what really I've been dealing with and helping clients on, is how to navigate those type of contractual relationships with these contractors or promoters that really did subpar analyses. And now it's the client that's on the hook from the IRS. So Kathy, would you mind going to the next slide? The IRS has really gotten up to speed on the ERTC, and they've issued a lot of guidance as to what would be improper eligibility. So, they've issued tens of thousands of clawback notices of folks who have received the ERTC. They've issued thousands of instances of disallowing unpaid claims. So I'll mention this at the end of the program, but if your company receives this notice from the IRS kind of wanting to dig into your eligibility factors of the ERTC, I'd encourage you to pick up the phone and give us a call, or give your accountant a call. But today I'm just going to go into these factors that the IRS has specifically pointed out. And this is not an exhaustive list, but this is what I commonly saw in the analysis of some of these promoters. So the first one is that just a general warning that if your consultant said, hey, there's nothing to lose, well, there is. Businesses should be on high alert if a promoter, urges them to apply for the credit based on this type of language, because businesses do have something to lose. You are at risk of repayment requirements, penalties, interest, an IRS audit, and then not to mention the potential expenses of hiring someone like us to get, to resolve the incorrect claim. The second one, I'll kind of dive into the first eligibility factor that a lot of people, very loosened the requirements was, the IRS is saying that a lot of government orders actually don't qualify. There are pretty strict and relatively straightforward guidance as to what type of government orders qualify. So the types of government orders are: government orders must have been in effect, and the employer's operations must have been fully or partially suspended by the government order. And I know we're like, oh my gosh, this is back in pandemic era, but if the IRS is auditing you, you got to dust off your file and look up your justification in your government shutdown order justifying for the credit if you're relying on that eligibility factor. So what I saw a lot, and what the IRS has specifically pointed out, was that there are a lot of justifications for this eligibility relying on OSHA guidance. I saw this a lot, and it was very murky. The IRS has specifically said that it's unlikely that communications from OSHA constitute a government order. So if you see the package that your ERTC consultant provided you and say that they're relying on OSHA guidance, I'd be very concerned. So another thing that the IRS has pointed out is how businesses have been unable to support how a government order fully or partially suspended business operations. So whether a business was fully or partially suspended just depends. When asked for proof on how the government order suspended more than a nominal portion of the business, many businesses haven't provided enough information to confirm their eligibility. This is a big one: supply chain issues. And this was a creative argument that I saw in a lot of the promoters' analysis why folks were eligible for the ERTC. So generally speaking, if, say, your business wasn't directly impacted by a government shutdown order, you could still say, well, my supplier was shut down. I wasn't able to get the supplies that were essential to my business. That affected me to be shut down. So, and again, saw this in many consultants' analyses. So a supply chain disruption is pretty uncommon, and you have to show that the government order caused the supplier to suspend operations, that you couldn't obtain your supplier's goods or materials elsewhere, regardless of the cost. A lot of folks, didn't appreciate that fact. And it caused a full or partial suspension of your own business. And then also, a lot of promoters convinced many essential businesses to claim the ERTC, when in many instances, essential businesses weren't eligible at all because they weren't fully or partially suspended. And then also the concept of double dipping. A lot of folks, potentially use the PPP funds as eligible ERTC credit, and that's obviously not allowed. So here are just a lot of the high level points. I would highly encourage you, if you know that your company did get an employee retention tax credit, to make sure that you have a good file with good justification. If you're concerned about your eligibility, there are ways we can go about it and kind of get in front of it. And Kathy, would you mind going to the next slide? So obviously, reach out to us. There are a couple options, and your company may be eligible or may not. I would encourage you to reach out to your accountant too. You can withdraw your claim if you haven't yet received your money. You can potential withdrawal of your claim is available. You may be able to amend your return if you, say, have an overstated credit eligibility. There's also a second voluntary disclosure program. It's available to folks that applied for the 2021 credit. It's if you cashed or deposited your credit check, it allows you to repay the credit at a reduced rate of 85%, and applications are being accepted only till November 22nd. So that's all I got. If you have any questions, please do not hesitate to reach out, and or your accountant. Thanks all.
Thank you, Liz. That was very thorough. And as you point out, it's important to be clear about justifications and to be able to trace back decisions that one made, perhaps under the difficult context of the pandemic, but that under the scrutiny that the IRS is employing, really need to stand up. So we are here to help if you have questions, and Liz is someone who's particularly versed in the program. Now let's move to our final speaker for our program today, and that's Chris Cruz Sierra. We're thrilled to have Chris with us. Chris has not been on the program before, but is someone who has a lot to offer all of you. He is based in our New York City office after having spent a lot of his time training in Florida, both undergrad at the University of South Florida and then his law degree at Florida State. And prior to joining Bond, Chris was a law clerk in Orlando, and he also clerked at a firm in Tallahassee, and brings that knowledge of someone who knows this area from a slightly different geographic vantage point to our clients and friends. Of course, we have an active practice in Florida generally, and we are just glad though that Chris is here in New York City with us. And today he's going to be talking about Title IX, which is an area that he spends a lot of time on in his practice. I think you'll all be glad to learn what Chris has to share with all of us. Certainly, I'm looking forward to it. And Chris, with that introduction, I wanted to turn it over to you. Thank you again for joining us, and welcome.
Of course. Thank you, Gabe, for having me. And I'm so happy to be here. Hopefully, everyone finds this information useful. Again, I will be providing updates on the recent Title IX regulation amendments that went into effect August 1st of 2024, and mostly bringing your attention to two new guidances that were issued by the Department of Education on September 12th of this year, so not too long ago. Kathy, next slide, please. Before we get into the two resources, I'd like to mention that recent injunctions have barred the Department of Education from enforcing the new Title IX regulations in many different states and in many institutions across the United States. Over 26 states, the Department of Education cannot enforce the regulations in 26 states. And I'm just going to name a few, not all of them because there are a lot, but just so that you can get thinking about which states are included in this list. We have Alabama, Arkansas, Florida, Georgia, West Virginia, and Wyoming, for example. And the list of the institutions is very exhaustive. It's a long list. However, we do advise that the regulations related to what I'm going to cover today are the least controversial as it relates to pregnant students and pregnant employees. So we expect that some form of the regulations pertaining to pregnant students and employees will be in the final form in the future. Next slide, please. As a general matter, Title IX prohibits and protects against sex discrimination based on pregnancy, childbirth, termination of pregnancy, lactation, or related medical condition. And I'm going to get into the related medical conditions in a second, but also as a blanket protection, it also protects recovery from pregnancy, childbirth, termination of pregnancy, lactation, or related medical conditions. So again, the definition of medical conditions is a little murky, but next slide, please, Kathy. But it includes morning sickness, fatigue, nausea, dehydration, gestational diabetes, preeclampsia, prenatal or postpartum depression, infertility, recovery from childbirth, miscarriage, and the list goes on. It's non-exhaustive. So it is important that administrators and Title IX coordinators take a look at this list to make sure that they are aligning their policies and procedures to the new regulations. And the preamble clarifies that discrimination based on menstruation, perimenopause, menopause, and related conditions also constitute prohibited sex discrimination. So again, the list is very exhaustive, non-exhaustive. It includes many, many things, and it's important to take a look at it. Next slide, please. The first resource, oh, and actually going back to the previous slide, Kathy, if you will, please. In a recent seminar, someone asked if IVF treatment was included in the related medical conditions, and it is. It falls under the umbrella of infertility. So if a student or employee is seeking infertility treatment such as IVF, it is protected under the new regulations. Next slide, please. Now, in regards to the two new resources, they were issued September 12th, 2024, and they're both aimed at helping schools, including colleges and universities, and school administrators comply with the new amendments to the Title IX regulations. They explain and clarify and update longstanding obligations related to the Title IX coordinator. That's the first resource. And the second resource describes the prohibitions on sex discrimination based on pregnancy, related conditions, and parental, family, and marital status. So not only pregnancy and related conditions, but also parental, family, and marital status. Next slide, please. The first resource as it relates to the duties of the Title IX coordinator, the first resource is it's very expansive, but it includes a lot of information. But some of the information that you will find in the resource is listed here for you. It'll answer questions such as what training must be provided to a Title IX coordinator, what must a Title IX coordinator monitor for barriers to respond to sex discrimination, the steps they should take in response to possible sex discrimination, when a Title IX coordinator is not responsible to respond to such allegations, and what actions must a Title IX coordinator take with regard to a student who is pregnant or experiencing a pregnancy-related condition, and the record-keeping responsibilities of Title IX coordinators as well. Next slide, please. As it relates to the second resource, it's titled Non-Discrimination Based on Pregnancy-Related Conditions and Parental, Family, and Marital Status. It indicates that schools must not, one, discriminate against individuals in the protected groups. And those protected groups, again, are students, employees, and those seeking admissions or employment with the institution. Schools must not treat those in the protected groups differently based on their parental, family, or marital status, or punish or retaliate against them, especially not for seeking protections under Title IX. Next slide, please. As it relates to applicants for admission, so these are perhaps future students, schools must not treat an applicant's pregnancy or their related condition differently than any other temporary medical condition. Next slide, please. And as it relates to students, the guidance is a little bit more expansive. Upon proper notice of a student's pregnancy or their related condition, a school must take some immediate actions, but notice is required. If the school does not have notice of the student's pregnancy or their related condition, these duties do not kick in. But upon proper notice, a school must notify the student about its responsibilities to pregnant students, which includes its obligation to respond to sex discrimination and limit the sharing of private information, and also provide the school's notice of non-discrimination. It must allow voluntary access to other parts of the school's education program that are comparable to the one the student currently attends or is in. It must allow voluntary leave of absence and reinstatement to the academic status the student was in before the leave began. It must also allow the students access to a lactation space and provide reasonable accommodations. And this is one of the biggest issues in the law. What is a reasonable modification? And that is on the next slide. Some more information on the next slide, please, Kathy. The institution must make reasonable modifications to its policies, practices, and procedures as necessary to prevent sex discrimination and ensure equal access. And this is important here. The Each reasonable modification must be based on the student's individual needs. So this is on a case-by-case basis that the school has to kind of undergo this process of determining what is reasonable under the circumstances of the specific student. So there should not be a blanket statement or a blanket rule as it relates to reasonable accommodations for students and employees as well. However, a modification that the school or the institution can demonstrate alters the nature of its education program is not deemed to be reasonable modification. But again, in mitigating for future litigation, perhaps the school would want to ensure that it's compiling a group of individuals, like a panel, to ascertain whether a request from a student is a reasonable modification. Next slide, please. Again, the student has the discretion to accept or decline an offer that is made in regards to a reasonable modification, but once an offer is made and the student accepts, the institution must implement it. And here are some examples of reasonable accommodations. Again, this is a non-exhaustive list. Breaks during class to express breast milk, breastfeed, or attend health needs associated with pregnancy or related conditions, including eating, drinking, or using the restroom, intermittent absences to attend medical appointments, and access to online or homebound education. And this one's quite important because now, after the COVID-19 pandemic, we have come to realize that a lot can be done via Zoom. And so if a class via Zoom has been offered as a reasonable accommodation to previous students, then it is something that should be considered for in the future for a student who is pregnant or experiencing a related condition. Next slide. Here are some other modifications that may be deemed reasonable: changes in a schedule or course sequence, extensions of time for coursework, allowing a student to sit or stand, counseling, changes in the physical space or supplies, elevator access, or other changes. And this is important because, especially for students who are in licensure programs, is it reasonable to accommodate the student if it's going to change the amount of time it'll take for the student to obtain the licensure? That's something that should be considered at all times. Next slide, please. Here's some suggested best practices. We suggest that the institution consolidates all pregnancy and lactation policies into one standalone policy so that the student or employee can find the policies related to their specific situation quickly. Consider a team approach to discuss academic accommodations. We also suggest that the final decision maker for academic accommodations be a dean or a provost. Again, these are very important decisions that should be made with someone by someone with authority. For programs leading to licensure, as I said earlier, check on the restrictions to see if flexibility is possible. If not, it may not be deemed a reasonable modification. Determine whether the requested modification or accommodation has ever been provided before. This will mitigate against issues regarding discrimination in the future. If leave is the best option, reasonable modification, and a student requests a tuition refund, we suggest that the school considers perhaps a tuition credit for the future. And although the ultimate decision lies on the institution, student requests must be and should be taken seriously and seriously considered. And again, as I said previously, never say never. Don't have a blanket statement to any request of reasonable accommodation. Always determine whether something is reasonable or not based on the circumstances of the student. Next slide, please. And as it relates to the employees, the guidance was very specific, and it states that a school must treat pregnancy or related conditions the same as any other temporary medical condition for all job-related purposes, whether it be promotion, whatever the case. Allow voluntary leave of absence if the school does not have an employee leave policy, or if the employee doesn't have insufficient leave or accrued employment time. The school must also, or the institution must also reinstate the employee to the status held before the leave began, without a decrease in pay, promotional opportunities, or any other right or privilege. The school must provide reasonable break time to express breast milk or breastfeed. It must provide access to a lactation space. And this is very important during the hiring process. An institution must not ask for the marital status of the perhaps future employee. And with that, that covers my section. But again, the guidances provide a lot more information than what I just did in these 10 minutes. But I hope you found this information to be useful. Thank you.
Thank you, Chris. Certainly I did. I'm grateful that you took the time to join us today, and please come on to the program whenever you have additional content to bring to this audience. And we know we are nearing time, and so what we want to make sure that you all have in mind are excuse me, the labor and employment law fall breakfast briefings. What you see arrayed here is a listing of all of those. Some of the dates are behind us. The ones in September, of course, have already happened. Melville is today. Westchester's October 10th, Watertown October 24th, etc. So if there's one still available in a geography that's nearby you, please try to sign up, because we expect it'll be helpful information for you and for your businesses. And I'll mention a webinar that I'm going to be part of delivering on October 7th. That one pertains to the part of my practice focused on healthcare delivery. Many of you likely have heard about an 1115 Medicaid waiver in New York State that's bringing about $6 billion with a B dollars into the state for programming. We're going to have a webinar concerning some of that, get into the details in the webinar on October 7th at noon. If that interests any of you, just reach out to me directly and I will make sure that you get the details and get signed up, because we would love to have you. Finally, in terms of programming for this webinar, you have ways to reach all of the attorneys, and for Chris, if you need to reach him, you can always go through me. Just make sure that you're also, if in need, taking a look at our sexual harassment prevention training tools, which are certainly ones that a lot of the organizations that tune in here have taken advantage of, and we think that they'll be useful for you if you need them for training requirements, etc. And we have the employment law essential guide, of course, always available. And we look forward to having you back on the webinar. The next time we'll all be together will be October 15th when I'm hosting. But prior to that is the 8th, which is the immediate Tuesday following this one. And Kristen Smith will be with you at that point. And I really look forward to having the chance to speak with all of you on the 15th. In the meanwhile, again, have a great start to this month of October. Enjoy fall, and we are here to help. If you have questions, don't hesitate to contact us. Thanks again.